I guess let's go ahead and do it now.
Okay. So
Okay.
we are live streaming.
Very good. Well, thank you guys so much for joining us for another meeting. One of the participants that was very helpful in our earlier meeting is unable to be here. So that means that we may have to reconvene before our meeting in July, but let's see what we can get done today. I want to thank all of y'all for coming, and I want to turn it over to Nicole to update us on what has happened since our last subcommittee meeting.
So at the last subcommittee meeting, you all may recall that you directed me to include 2012 FEO 9, which is the opinion, and I think it's a child custody case where the lawyer who is appointed dual roles has to ask the court for clarification on what their role was going to be. So I incorporated that into the proposed opinion. At our last meeting, Sydney suggested that we send the proposed opinion to some of the stakeholders to see what they have to say before we present it to the ethics committee and before we publish it for comment. So I did that. I sent it to Wendy Sotolongo she's the parent defender with IBS. And I sent all of you your comments, so let me know if you don't have all of that. But she thinks that the opinion is well-grounded in the rules and the ethics opinion. She thinks that one of the assumptions in the facts that the lawyer has to fulfill the statutory obligations of the GAL program and the ethical duties under the rules of professional conduct may be incorrect, in that she says that the GAL program is policy and not statutorily required. She points out that under 7B 601, that's the appointment of the GAL program in abuse, neglect, dependency cases, that the GAL program will be appointed unless there's a conflict, in which case then the lawyer is appointed under 7B 1202. But she says that the requirements set out in 7B 601 are not repeated in 7B 1202. So therefore, she thinks that we need to make that clear to clarify that. She agrees with the 2012 FEO 9 applying, and she offered a few very minor revisions to the opinion. One was actually a typo, but nothing else really substantive. Reggie O'Rourke, who was the lawyer who submitted the inquiry, provided a response on behalf of the GAL program. And he basically points out that that Supreme Court case, in Ray RD, is applicable. That case was about a termination of parental rights, but the Supreme Court allowed the lawyer to serve dual roles, but include their GAL report that goes to the court at the stage, the best interest stage is what he said it was. And that opinion should be incorporated into our proposed opinion, and our proposed opinion should allow the lawyer to submit the GAL report. He pointed out that the court carefully considered Rule 3.7 and the 7B 601, as well as the juvenile code, and therefore that Supreme Court decision should control our ethics opinion. Gail Sorelli, who is with, let's see, I'm sorry, where is she? DHHS. She says that her clients don't have any comments at this time, so they may have comments later, and I can certainly, whatever we decide to do, I can send the opinion back to her. Wendy Sotolongo. I'm sorry, I got that wrong. Wendy, she's the parent defender. I'm sorry. Sarah D. Pasquale. She's the one who commented yesterday evening, and I sent that to you this morning. So if you didn't have a chance to read that. She also points out in Ray, that Supreme Court decision, gosh, I forgot that quick. That's a sign of me getting old, right? In Ray RD. So she also pointed that out. Her comments are pretty extensive about what we've got wrong in the opinion. And I think what I took away from it basically was that the lawyers should be following the law. And the Supreme Court allows for the lawyer to serve this dual role. And therefore the ethics opinion that says differently is incorrect. So that's my summary.
Okay, does anyone have any comments at this point based upon these additional comments that we've received from the stakeholders? And then I guess, Nicole, what are your thoughts on what our next steps should be?
I think we need to reevaluate this opinion and look at what the Supreme Court case allows and then apply that. I will point out that generally, a lawyer's obligation is always to follow the law first, and then the rules of professional conduct and the ethics opinions. So I think we need to carefully consider the ramifications that Sydney pointed to us about telling lawyers, if you serve this dual role, you can't testify, when that is the expectation of the court. It sounds like, and at least what Sarah says, is that the lawyer should be able to testify as well as submit that report, because if they don't, then it has dire financial consequences to the GAO program, because then they have to pay two people, one of which might has to be a lawyer. The other can be a non-lawyer, but they would have to appoint a GAL volunteer, as well as, I'm sorry, not the GAL program, the court would have to appoint a GAL volunteer as well as an attorney advocate. And the cost of that could be felt tremendously, especially in the smaller communities. And I think Sarah, as well as Reggie, said that 2012 FEO 9 are a different set of facts. In that 12 FEO 9 is about custody and visitation, whereas the requirements of a guardian ad litem are different in those cases than they are in abuse, neglect, dependency cases. And I think at one of our first meetings, Gina was raising some concern about how the opinion would affect GALs in custody cases. Is that right, Gina?
Yes, ma'am. In that context, what happens often is that a contested custody case where there's really something significant going on, the court appoints a GAL, and at least in Mecklenburg, we have the benefit of having an organization that bifurcates the roles. There is an attorney who is serving as a guardian ad litem who does not testify. And then the attorney has a wingman called a custody advocate who actually interviews teachers and parents and does home studies. And the GAL actually calls the custody advocate to testify. And so in counties that have the resources, their custody organizations that can fill that gap. However, I have been appointed by courts to do both roles. I have tried to cross-examine lawyers in cases who've been appointed to do both roles. And it's hard to do consistent with the rules of professional conduct, because you are absolutely a witness and an advocate with sort of no protection. And I think it will, I almost think this needs to be statutory. I mean, I think we're carving out a giant exception to the rule that when a lawyer can't do both functions. So I don't know exactly how to solve the problem, at least in the context of the custody arena. The juvenile court context might be a little bit easier, but when you're talking about a GAL, you're talking about a GAL in multiple capacities. So I don't know if we narrow the opinion or what. I think it's kind of a mess.
Well, that's what I was sort of thinking, if we did need to, in order to get it right, narrow it to specifically the abuse, dependency, neglect trials, but since that's particular to the question that was asked, I don't know. Does anyone else have any thoughts on that?
Well, I will say I see Dorothy had a fire alarm, and that's a shame, because I really look forward to her insights in this. I know she has way more experience in this area than I do. I reading this material and looking at these letters, I think it's definitely clear that everybody is struggling with the right questions about how do we preserve this process in a way that looks after the kids, but also make sure that lawyers are doing the ethical thing. I would love to say that this is a legislative problem and then just kick it to them. Unfortunately, I kind of think that we have an obligation to speak on the ethical issues related to an attorney in a dual role. It's the dual role is how I got involved with ethics committee. Nicole probably remembers this. 5 or 6 years ago, there were a series of issues related to the dual roles that mortgage trustees were involved with when they were also advocates for the bank in a foreclosure action. So they were supposedly the guardian of propriety and making sure that everything was neutral, and at the same time advocating to a judge why this house needs to be foreclosed on it, and it didn't work. And but there were a series of FEOs that came out to deal with that, and it has worked, by the way. Just as an aside, they've worked very well, and we haven't seen these problems in the past. So, as a person who got involved in the ethics committee on a similar, it's not perfectly analogous, of course, but a similar issue, I do think that we should address the ethics of the dual role. In a former life, I did corporate defense before I joined legal aid a few years ago. And in the corporate defense world, we had a slew of cases that we also handled for insurance companies. That's a whole journey into itself. But there was also the dual role of representing the insurance company versus the insured. And there were all kinds of ethical issues that we had to deal with that. So my point is just simply that I would love to kick it to the legislators, but I feel that we probably need to speak on the ethics of a dual role situation. I know we also have one right now, don't we, where with another subcommittee where you have the issue of whether or not one attorney can represent multiple parties at a closing, for example. So I think these issues are very important, and I do think that some guidance from us is probably, if we can do it, we probably should.
Hey, Jack, I think the important distinction between those other dual role issues and this one is
that was I like what Nicole wrote. I also hear what some of these people are struggling with in these letters, and and on this committee. My big thing, and I'm just going to reiterate kind of where I ended last time, where I'm still at, is my big problem is from a, you know, from the perspective of, if I had a client who potentially could lose custody of their child. You know, when I do mortgage cases, I argue to the court that the home is the most important thing, but really the relationship with their children is going to be the most important thing. I think maybe a human being has is their capacity to have a relationship with their child. And if we're talking about the outcome of a case that could have, as Nicole said, the ramifications like that, my gosh, if I don't have the ability as an advocate on the behalf of a parent who might lose custody of their child to cross-examine what may be the only fact finder in this case, that is the author of the GAL report that is being recommended to the court, you should do X, and you should do X because I interviewed these 5 people and did all this stuff, and that is those are the only facts. Court, if I don't have the ability to cross-examine that person, I don't see how I can possibly be an advocate. And so my question is, can we say they don't have to testify, but they may be called to testify, right? In other words, when I look at this right now as it's written, may not testify as a witness, does that mean I don't, as the advocate on behalf of a parent who's about to lose custody of their child, have the ability to call them as a witness to cross-examine them during the trial? If I don't see how I could possibly ever do my job.
Interestingly, the court said that cross-examination wasn't a right.
Which is nonsense.
Thank you.
I mean, you know, and that's what I was going to say earlier in the examples that Jack was giving us. He's talking about conflicts in representation duties. What we're talking about here is the conflict between representation and being a witness. A GAL is called upon to do both of those things. And that's where, to me, it's problematic, because that opinion is absolutely incorrect. It is a constitutional right for a parent to cross-examine a witness at a custody case who has done fact finding and has testified about it to the court. And that's a layup, y'all. That's not even hard. So that's what we're doing, is we're putting these lawyers who the court desperately needs to get to the truth of the matter, we're putting them in an impossible situation. So I think we have to protect them while allowing courts the ability to use GALs in both the juvenile court context and the family court context, so that we can get the facts out there.
Does anyone have any other comments? Those were, I agree with you, Gina and Jack. Those are very important. Almost it's what our system is based on. Things that this opinion could impact, and it would be very hard to be told you cannot cross-examine the one witness that might be the important witness in the case.
Your chief accuser in some respects. And last time I was involved in this, it turned into quite a ruckus where, you know, we were making arguments about substantial rights and immediate appeals and things of that nature. So it's a big stick of dynamite.
If I could add, and I apologize, you all, we had this little debacle here, and I didn't hear everything that you were saying, Ms. Morris, but I caught the tail end, and it sounded like I would have been on board with everything that you're saying. But I'll add, when you say that they have some serving as a guardian ad litem, and having served as a guardian ad litem on both sides in family court cases, as well as in abuse, neglect, dependency cases, and been in a a parent attorney in those abuse, neglect, dependency cases in these situations, as well as serve as an attorney representing someone in a custody case, you are absolutely correct. Most of the time, at least in my experience, the judges give lots of weight to what the guardian ad litem actually says and recommends. And so in addition to being able or not having the ability to cross-examine them, you also have the issue of all of this hearsay that is included in these guardian ad litem reports. I will tell you, even me, I took pride when I used to do these, in the investigation that I would do is very thorough. Like I would go and talk to the kids, the teachers, the therapist, like everybody. And so folks like that, because then you're getting all this information in your report, in the GAL's report, that they don't have to go and now subpoena the therapist and all of, you know what I mean? So it really is, it encompasses a whole lot more than just that whole lack of cross-exam or infringement on the cross-examination and that constitutional right, but also the evidentiary side of things. And especially if you have someone that's pro se that doesn't, is not well versed in how these cases go and, the rules of evidence and, all of that. And so you want to have some safeguard in there for that as well. Oh, what I said, was that powerful?
That's what was sinking in. Thank you.
Hey, Nicole, can we ever do anything like punt and say in the opinion that acknowledging the dual role issues and saying that as long as the lawyer is complying with a direct, and I think we did this a little bit, but complying with a directive given by the judge at the time, who outlining the parameters of the representation, that's okay.
We have to be careful there. We have not done that much in ethics opinions. I know from the grievance side, and Brian is here and he can maybe refresh my memory about this, but the grievance committee is not sympathetic to lawyers violating the rules because the judge said they could. Is that right, Brian?
Yeah, I would say so. Can you all hear me, by the way?
Yes.
Okay. Sorry, I'm technically in a CLE presentation that I was just giving and then switched over to this. So hopefully I have my microphone on mute on the other computer. But the thing, yeah, I would say yes. I don't think the grievance committee loves that, but I think the grievance committee does recognize the concurrent jurisdiction that judges have over matters of professional responsibility. And so I think in that regard, that's what I'm wondering, to your point, Gina, if the judge appointing somebody, if this is seen as, the judge, are we allowed to presume the judge is aware of the potential conflict that is being created in this situation? That essentially the judge is, I guess, recognizing the practicality and prioritizing the practicality over the need to be cautious and have everybody split off for conflicts and things of that nature. I wonder if the opinion can make some sort of statement that essentially the court is aware, or clearly the court would be aware because if they had a problem with this, they wouldn't appoint somebody in this capacity. But the grievance committee, I think their response, and Marcy, you've served on the grievance committee as well. You were one of our vice chairs. But I kind of feel like the grievance committee recognizes that essentially lawyers can be put in awkward situations when judges say, do this, and the lawyer's like, I don't know if I can. That brings up some ethical considerations, blatant rule violations. No, you can't just you never just take your hands off the steering wheel of your own ethical car. But at the same time, being appointed in this capacity to have the grievance committee come back and say, well, we just disagree that the judge should never have appointed you because they should have been aware of the conflict issues. I don't know that the grievance committee would get all kind of up in arms about that, but that's my take.
I think if the ethics opinion, tells a lawyer, you just make sure the court is aware, but also the court can review the Supreme Court case and make decisions based on that. And then I think the lawyer has better coverage where, if our ethics opinion reminds the lawyer to review this case, or maybe go a little bit more than that. I mean, I think I'd like the opinion to come to some conclusions similar to what was found in the Supreme Court case. And then I think the lawyer has more protection. But it will all depend on what you all want to do. I mean, do you want to leave the answer the way that it is, or do you want to make an about face and change the answer and say that the lawyer not only can submit this report, but also testified if called upon to do so by the court?
For what it's worth, and I'm not well versed in this opinion as you are, as well versed in this opinion as you all are. But I just wanted to kind of point out something. I know Nicole and I talked about this, and you all may have touched on this before, but the potential similarities in thought process between this and some of our opinions on the Attorney General's office. The AG's office can be in conflict with itself, with imputed conflicts all the time. You can see how agencies have to sue each other or have a divergent interest. And theoretically, it all comes under AG Stein, and does everything get imputed and suddenly the AG's office can't represent anybody? And the answer is no. And the opinion, Nicole, you probably have the number. Is it RPC 55 or something? It's an old opinion from, I think, 89. And it basically recognizes, it's a short answer, but it recognizes the impracticality of applying the rule in that regard. It is not, to me, a model of how we should always approach ethics opinions, of just saying, well, this isn't practical, therefore we're not going to apply the rules. That's not a great thing. But I think in that situation, it was appropriate to note that it would be impractical to put the Attorney General's, or I guess kind of this notion, I know, Nicole, I heard you mention before, lawyers to follow the kind of law first, statutory law, and then the rules of professional conduct. And in that regard, the Attorney General's office is the one that is authorized and relied upon to provide this representation to these agencies. It's impractical to impose the notion of conflicts and imputed conflicts on that agency, because it would essentially bring everything to a halt. I don't know if there's a similar process here, if there's a similar thought here, to note that it would be impractical to basically disqualify and via the conflict analysis and disqualify, maybe tear down the way that we've been handling and appointing GALs in that regard. Of course, I think that thought is probably strengthened by the notion that the AG is statutorily authorized to represent everybody. In this situation, I heard earlier briefly that, it may not be statutory. The GAL program is a bit more policy than statutory, and that brings a, not as solid footing. But I do think that thought is worth exploring to the extent that we can still respect the intent of the rules and the application and the protections that we're concerned about, while also recognizing that maybe direct technical application in this limited situation may be impractical. I don't know what you all think of that. I'd love to hear.
I think it's wonderful.
It's just one of those things that it becomes, you don't want to get into that slippery slope of just going down that path, but it may be appropriate to craft something here very limited, very narrow. And in that regard, maybe that converts this, not necessarily from an FEO, but to an ethics decision. Clearly it's going to be sent around, but it could be something that's from the council, but not necessarily published. It could be something that's sent back to Mr. O'Rourke and he can rely upon it. And perhaps I'm sure he would share it with other GALs and so forth. But if that could be kind of almost like a testing aspect. If you start getting a lot of pushback and a lot of further confusion, then, maybe we have to go to an FEO, but maybe that's just kind of a first step, because we do have options here.
So how does everyone, I guess that's the first I've thought about changing it over to a different animal. How do we
I
feel
agree
about
with that. That is a good approach. Could I add to that in that I think it's inquiry number 3, that if we, in the opinion that's included in it, that one asks it specifically about if how's it written? May a conflict attorney who drafted a GAL report be called as a witness by the court or another party? And the answer, the opinion as I review it, I get completely what it's saying, but I think it should be noted that the submission of a GAL report is not all that triggers the person being potentially called as a witness. And I think the answer gets to that, but it doesn't specifically say that. And I think it should include that. Does that make sense? Because even though the question specifically asks about the submission of a court report.
So you're saying the submission of the court report does not automatically mean the lawyer will testify?
That's not the only reason why.
Not the only reason.
Right.
Okay.
They don't even have to submit a court report in order for them to potentially be called as a witness. If they're known to be the GAL and everyone knows they're doing an investigation, them having a report or not, puts them in a position to be called to testify.
Does anyone have any other comments or thoughts about this and what we should ask Nicole to do as she's reconsidering the draft?
So I think what I need to know from you is, do you want me to incorporate this in Ray Supreme Court decision? The in Ray RD. Or do you want to go with Brian's approach that a strict interpretation and application of 3.7 is impractical? Or do you want me to come up with both and we have another subcommittee?
I think that would be helpful for me. I can see the benefits and issues on both sides.
Okay.
Same here.
Okay. And I can do that.
And thank you for being so wise to offer that third option, because I was sitting here trying to figure out how to answer you.
I think sometimes when you see it on paper, it does make a difference. So hopefully that'll be the case.
And it's very difficult for me because I'm like, I do this work, I've done a lot of this work. And so I'm thinking about it practically speaking, like, what's the big deal? Like, you just support 2 different people and keep it going. But
the concern is the monetary issue. I think that's what's the biggest problem, is that some counties may not have enough money to pay for 2 people.
Can I just ask one question real quick? And then maybe this is a question for Reggie and not for this group. The conflict that he raised when he sent you this inquiry, is his interpretation of that the GAL program over the entire state is conflicted out when one county's GAL program is conflicted out? Because it seems like you could insert neighboring county to come over and handle a conflict case and you wouldn't have an issue. Just like we do sometimes with attorneys where there's, every attorney in where I am, it's, fairly rural. So let's use Anson County as an example. I've been called over there over time for cases because all of the attorneys in Anson County don't want to touch a case. So they call me over there to do it. And it seemed like, I know there's clusters of counties with the GAL programs, but here we have 3 counties. We have, that are under the umbrella of our GAL program. It seemed like you could draw from another county and this whole conflict thing goes away.
And you're saying, are you speaking, Mr. Webster, about drawing from another county on the attorney advocate or the GAL?
Well, both.
Volunteer.
I guess both, maybe for some type of a conflict case, sort of like what DSS does when they have a conflict case. They go to the next county and ask them to handle the investigation or whatever the case may be.
I think I'm trying to think this through. So it seems like it might be okay on the attorney advocate side to borrow someone from another county, but not on the GAL volunteer, because those GAL volunteers volunteer specifically for that county. Yeah. And they get the training and all of that in that particular county. And so I think, it'd be more of an issue with that. And I would think that's what the guardian ad litem's office position would be, because I know, for instance, in those A&D cases that we have, if we have a kid that is in DSS custody and they're moved out of county, they raise a big ruckus with their GAL volunteer, even going to these other counties sometimes to do their investigation. So, and not getting a lot of assistance from the other county in that little investigation. You know what I mean? So,
yeah, I understand. I guess that doesn't eliminate the problem, because it doesn't matter if it's the attorney advocate from here or somewhere else, they're still going to run into this issue. So, anyway. Okay.
Well, are there any other thoughts that we need to talk about before we dismiss and reconvene? Nicole, do you have any particular questions for us?
I don't think so. So I'm going to draft 2 different opinions. And after I get off this call, I'll get with you, Dion, so that you can give me your available dates. And then we're going to set up a new meeting, and rather sooner than later. So if that works for everybody, then that's what we'll do. Good. Oh, Dion, you're muted.
Yes, there we go. I do think it would be helpful, and we may want to shoot out something to Sydney, since she didn't get to come to this one, just to see if she has anything further to think about, and make sure she can come to the next one.
I imagine her week is going to free up, or her time will free up after this week.
Yeah,
It seems like things are pretty busy at the General Assembly.
Yeah, that's where she is. That's what she said, that last night they called a meeting for 10 o'clock or 9:30 this morning. So,
yeah.
Okay, well, with that in mind, is everyone comfortable with dismissing now? Adjourning? Okay.
Good luck, Nicole.
thank you, Gina. Do you want to write it with me?
No way. Not
Sorry,
capable.
I opened my big mouth, Nicole.
Yeah,
Brian will help you.
Brian and I are in the same department, and he's my boss. So guess what? Whatever I'm writing. All right.
Well, thanks, guys. We'll see you, Nicole.
Thanks, everybody.